So we're going to move on. We're a little running long today, but I'm going to have Christopher Donovan from Doss Law. Dennis Doss has been my lawyer since 1996, and he is the premier guru lawyer in the industry that we work in and the industry that you folks invest in. And he's done a great job with all of our documents and also just keeping us in compliance. And compliance is something that we don't mess with. And so anyway, I have Chris here. He's going to give us just an update on any changes in the legislation. Default interest has been a topic recently. So anyway. That being said, he walked off with it. But anyway, Chris, are you ready? You can start with this or start with that one. Jeff just ran off with it. I'll have to get it. But anyway. You want this thing or you want that
one? That's embarrassing.
Can you hear me? All right. All right. Thank you for that introduction. I appreciate it. Just real quick, house cleaning. This is educational purposes, not legal advice. Okay. All right. Sound good? Good? All right. All right. My name is Christopher Donovan. I'm a partner of Doss Law. As James referred, my mentor is Dennis Doss. He's been practicing in the space for 46 years. I used to do commercial finance and then jumped over to the legal side, and I've been with him for going on 10 years, learning everything I can. So that's a little bit about me. All right. We're going to discuss 4 different bills today. We'll start with the one that I think is the most draconian and one to be the most concerned about in the private money lending industry today. It's AB 3108, mortgage fraud and compliance requirements. So a little backstory on this is how did we get here? We had a lot of liar loans and non-prime borrowers before the Great Recession. After the Great Recession, they instilled some rules that tightened credit, ability to repay, prohibition on balloon payments, fully amortized loans. You have to prove that ability. You couldn't do these stated income, stated asset loans, these liar loans anymore, which paved the way for the private money lending industry, which was a great thing for our industry because so many less people were bankable. So a homeowner that cannot qualify for a bank loan has 3 choices. They could sell their home and rent, sell a portion of their equity, or obtain a fake business purpose loan. Are borrowers complicit in these fake business purpose loans? Yes, they are. They're very smart. They go to the first private money lender and they get turned down because it's clearly a consumer loan. Then they realize, oh, I need to start a business. So they start a sham business, they put the home in it, and then they go to the next private money lender and pretend like it's a business purpose loan when it's clearly not. Why do lenders and brokers do it? Why do they make these loans? They think they're protected by their disclosures. They try to make sure there's enough protective equity in the asset that they'll be able to refinance out. The borrower sings a nice story that they have some, boon of money coming in and they're going to be able to refinance that loan, which doesn't always happen. They feel compassion. Obviously, they want to make money, and they think the law of averages are in their favor. The civil consequences for making a consumer loan dressed as a business purpose loan are reversing interest, unenforceable deed of trust. The attorney's fees are what's going to probably eat you alive because you're going to pay for the borrower's fees and your fees to defend it. We see these get racked up on a $250,000 fix and flip can be $500,000 in legal fees. It's pretty bad. That's why we don't litigate. Licensing defense or licensing discipline from the regulators, and upset investors. So the big deal about this one is it's not just civil anymore. As of January 1st, there's now your freedom on the line. There's criminal liability for making a loan dressed as a consumer loan that turns out, or dressed as a business purpose loan that turns out to be a consumer loan. Professional reputation. We do believe people, they didn't come out with this statute to not put people in jail. They're going to enforce it. People are going to go to jail over the next year or so. Let's see. The DRE is going to force settlements. Borrowers in their counsel, they're already using these letters against us. They're already using this. Our law firm, California Mortgage Association has about 300 private money lenders and brokers. We represent over half of them. We represent the majority of private money lenders and brokers in California. And we're already seeing borrowers, and we don't usually represent borrowers in any way unless someone's really egregious. But we're seeing Borrowers Defense Counsel already using this in their nasty letters to scare us and bring lenders to the settlement table. So what does the statute say? A mortgage broker or person who originates with the intent to defraud, if the person does either of the following: they instruct or deliberately cause a borrower to sign documents reflecting the terms of a business loan with knowledge that the borrower intends to use the loan for primarily for personal, family, or household use, so consumer loan. The other one in here is that if you try to use the consumer bridge loan exemption to be able to do a consumer loan at less than 12 months, because that's a private money loan. No one really is in this room wants to make a loan that's going to pay off over 30 years. So if you try to do the consumer loan exemption, and it's clearly not because they either didn't have intent to sell their current home, they didn't have intent to buy a new home, they didn't have that home in escrow, but you're trying to utilize that exemption so you don't have to deal with amortization, you don't have to deal with balloons, you don't have to deal with ability to repay, no documented income, all those great things about this exemption. If you try to take advantage of it when it wasn't the case, this bill will come back to bite you. So what does intent to defraud mean? The lender knew that it was for consumer purposes. Prosecutors are going to look for any kind of breadcrumbs in your emails, applications, anything they could see where you knew it was consumer, personal, family, or household use. What does instruct or otherwise deliberately cause a borrower to sign documents? Basically, you're a part of the loan document process. You provided them loan documents, you're instructing. Does it have to be secured by real estate? No, it does not. It's not limited to owner-occupied. And now I want to discuss ways to avoid this bill from affecting you so that you don't have to go to jail. Let's see, categorical exemptions. These are great ones. Bona fide entities. Bona fide entities are categorically exempt from Regulation Z, consumer purpose laws. Those are safe. Has to be bona fide. It can't be a failing business. It can't be a sham business. Loans to acquire, improve, or maintain non-owner-occupied properties. Those are wonderful, clearly exempt. Owner-occupied loans, if it's to acquire 3 or more, so the borrower can live there, that's still a business purpose loan. Improve or maintain, you can do that as long as there's 5 or more units. The borrower can actually live there. Let's see, so if you're making a loan to a natural person, you want 50% or more to be for business purpose. You throw out all the fees. What are the loan proceeds going? We say at least 65% just to be safe, but the law is 51%. And then when you have that situation, these are the things we think you should do to protect yourself. Get that handwritten statement of purpose, corroborate evidence of the business, get the business certificate, make sure they complete it. We see a lot of loan docs come back where they just left that document blank for some reason. It's very important that it's as detailed with as much specificity as possible. Use of funds isn't going to work. What are you doing with those? What are those funds actually going toward? I want to see a line item. Fund a business bank account if you can. We just implemented a borrower's attorney opinion letter that we provide that gives the borrower's attorney everything they need to send a letter to us to confirm it's for business purpose. It has all the statutes and regs there. We've been using that successfully. And we just started doing what we call a Zoom lock, where we do a recorded Zoom. We interview the borrower, make sure they're okay with recording, they're not under any drugs, they're of sound mind, and then we start asking them about their business purpose. And we get them singing the song of how all this money is going to go towards a business purpose, nothing's going to be towards consumer. Then we go over the material loan terms to make sure they understand everything they're getting. If borrower's counsel sends you a nasty letter, you send them that video and they go away. They're not going to pursue that. There are some traps. It's quite a few traps. Business gone bad. I discussed that a little bit earlier. You can't fund a failed business. That's not a business purpose. Thornton versus Sundance is a classic case where an investor invested as a limited partner. They have to be active in the business. If they're a limited partner, they're passive. That's not a business purpose. That's an investment. That's a consumer loan. The red truck case. Red truck case is mom buys a shiny new red truck for her son so he can run his business. That's not a business purpose to the mom. That's a business purpose to the son. So that would be a consumer loan as well. They're doing it out of love and endearment for the son, but not out of greed in the person's heart, not out of commercial gain. Peel the onion. If you're refinancing debt, you have to find out what you're refinancing. Was it a consumer loan? Okay, let's say it was a business purpose loan. What did that business purpose loan refinance? And you have to drill down, and if you end up with a consumer loan, it's a consumer credit loan. So you have to peel the onion on the loans till you get to a legitimate business purpose or a consumer purpose. Old home debt. A couple buys their starter home, they're ready to move on to the old home or to a new home and move up, but they have that Bank of America loan. If you refinance that, that's consumer credit, it's a consumer loan. If a beneficiary of a trust occupies the property, then it's an owner-occupied property, it's a consumer loan. Hobby flipper. I'm an attorney, I've flipped some houses, but I'm not a professional flipper. Me and my wife and kids can go swing hammers on the weekend, have some fun, demoing a house, but it's not a business purpose to me. I'm not in this business, so you gotta watch out for the hobbyist flippers who are not professional. Resort rental. We have a cabin in Lake Tahoe. Love Lake Tahoe, but it's that loan. If you're gonna live there for 14 or stay there for 14 days in the upcoming year, that's a second home, and that's no longer a business purpose loan, and it's a consumer loan. Owner-occupied ADU. This one is up in the air. There's no case law on it yet. If you want to build an ADU on your property, or your borrower wants to build an ADU on the property, they're going to rent it out. You think, okay, that's non-owner occupied. They're doing it for commercial gain. That sounds like a business loan to me. Well, it could be a home improvement loan. And we just don't have case law on it yet, so we are advising not to do that until you don't want to be the guinea pig that failed that one. And California judges they don't like attorneys, they don't like investors, they don't, they're very consumer protection. So we think that case is going to happen, and I think they're going to rule that it's a home improvement loan, consumer loan, protect the borrower, and it's going to be really bad for whoever made that loan. Fake business entity. There's case law on this where the borrower was shopping and got denied, and then one of the people said, hey, but your house in an LLC, it's a business purpose loan. The LLC has no other business purpose. It's just holding this property. That is a consumer loan. So all those can get you. You've got to watch for the traps. Our strategy, we kind of talked about it a little bit, but the handwritten letter is huge, corroborating evidence, the business purpose certificate, fund a bank account, and the two most recent things we've added because of this case and because we don't want to see any of our clients go to jail is the attorney opinion letter. There is an advice of counsel defense. We've been using this letter. Borrowers, attorneys, surprisingly, are very open to signing it. We haven't had anyone say no yet. They've signed it, and now we have more protection for our client. And then the Zoom lock that I discussed. The second thing we need to do is, first thing is the recipe. The second thing is to know those exemptions we discussed. And the third thing is to avoid the traps. Okay, this brings us to our next one, In Re Moon. This was a case that I think it was settled in 2022 and went through the court system. And last year, we were unfortunately having to rewrite loans that hurt borrowers. So the case, a lender made a loan that was broker arranged, exempt from usury. This is a usury case. They went to do an extension on that, but they didn't involve a broker. The court said, because you didn't involve a broker, it actually moved the interest rate from like 11.5 to 11. They gave them a better interest rate, but it was still over 10. The court said that this is a usurious loan. Two of the worst things you can do in this business is make a usurious loan or make a business purpose loan that turns out to be consumer. This one was usurious. And since then, the judge went on with dicta and said, even if this loan was arranged by a broker, it'd have to be arranged by the same broker, and it'd have to be a purchase money loan. So anything that wasn't in that scenario, we were having to rewrite the loan. This is intended to protect consumers, but it was hurting them. Instead of just getting an extension that cost them nothing, we were doing a whole new loan that's maybe, I don't know, $20,000 in closing costs after title, escrow, attorneys, you name it, all the fees. So very bad law. California Mortgage Association fought really hard. January 1st, it was signed into law last August, and became law January 1st. So we got that situation fixed. So we just made a couple changes. We changed the word "the" to "a," so it could be any broker now. We added that it could be a modification, forbearance, or extension, because that was kind of ambiguous. They were using different terms in different sentences. It was really poorly written legislation. Lenders cannot do this on their own if they're unlicensed private money investors, so you will need to go through a licensed DRE broker that needs to be paid a fee as well for the user exemption to still apply to loans that you modify, forbear, or extend. All right, there's some new foreclosure laws that just became effective January 1st. All three of these that I've discussed all became effective January 1st. Let's see, early intervention changes. This is for consumer loans. There's foreclosure changes that applies to all 1 to 4 and some things for servicers. So early intervention, when you do the 30-day letter and the call, you have to inform them that a third party, such as a family member, HUD-certified housing counselor, or attorney may record a request to receive copies of any notice of default. And by receiving these documents, the third party may be able to assist the borrower to avoid foreclosure. So early intervention things. This one's mainly listing agreements. So as long as it's 5 days before the actual foreclosure sale, they can get a listing agreement, postpone it another 45 days. It can only be used once. There's some criteria for it. You have to involve a broker. You have to deliver the notice to them appropriately. But any foreclosure company or servicing company should be pretty boned up on all these. That same person who postponed it 45 days can then get a purchase agreement and postpone it for another 45 days. The purchase agreement can only be used once. There are some requirements of what is a bona fide purchase agreement, but as long as it is, then they're going to be able to postpone it. So we're adding, to our already pretty long foreclosure process, we just added another 90 days potentially to it. Something that investors may want to price into the loans that they make. Fair market value. The trustee cannot sell the property for less than 67% of the fair market value at initial sell. That's going to be, usually it's going to be a broker price opinion provided from the broker involved within 6 months. Unsold properties must be postponed for 7 days, and the trustee can basically rely on it, doesn't have to verify it. There's new disclosures that need to be in your loan docs because of this law. California Civil Code 2932.2. This is effective January 1st as well. We've added this to our loan documents. Basically, it's that notice at the bottom that giving the borrower notice that they have the right to have a third party record a request to receive a notice of default at sale. Here's a little practical advice for you or for any brokers that you're involved with. Private money investors should be let known that this listing agreement and the other rule could postpone it 90 days. Consider revising investor disclosures. Let investors know about the 67% rule. And then for lenders, include in your loan package that notice at the bottom. And we put it right above the signature line in our security instruments for all 50 states. And this last one is just something to have on your radar. It is not effective yet. It's going to committee February 13th, so about a week. Basically, this will add another 180 days potentially. So any borrower that is experiencing financial hardship from the fires can postpone it up to 180 days. No additional documentation is required other than the borrower's attestation who is experiencing financial hardship due directly or indirectly, so that leaves it kind of vague, to the wildfire disaster. I mean, that could be potentially a business that isn't getting as many customers. They're directly or indirectly affected. So we'll see how that all plays out. It's going to committee, but it could, and during that time, there's no fees, no penalties, no interest. So I think anyone, and it only applies to owner-occupied natural persons, so anyone making loans in that an area that could be affected by the wildfires is going to have to price that into their loans, especially, or if it's to an owner-occupied natural person. But just something to keep an eye on. That's it. If you have any questions, let me know. Everyone's probably hungry.
You can see that there are a lot of mines, landmines out in our world, and thankfully we have Dennis that does all of our docks and so forth. We do, we have business and investment purpose loans all the time, and we do Zoom meetings with the borrowers, and we don't, oftentimes you'll hear a broker who brought the loan to us will then interfere or start answering or coaching the borrower along, as they're trying to get them a loan, and they're saying, hey, you got to say this, and I kick them off of the Zoom meeting, and I ask the borrowers what they're doing, and then they tell you the truth, and it turns out that it's not for business. But brokers there's nobody more broke than a broke broker. And they're happy to lie to you for a fee.